我哋夠鐘夠人啦，不如請官員入嚟先。
We've got a quorum already, so please invite the administration in.
呀，雙方。
唔係，
冇嘢嘛？
敏感啲。
敏感。余女士，謝女士，歡迎咁多位。
So welcome. With regard to issues raised by members at the last meeting, the administration has provided a response to the Bills Committee. This is paper CB 2712-01. Can Ms. Sher take us through the paper, please? Yes, thank you. This is a response to issues raised at the meeting held on the 20th of December last year. With regard to criminalization of parental child abduction, we agree with the LRC, and that is under the bill, there is the power to detain a child when he or she is about to be removed out of Hong Kong in breach of a stop order. We are of the view that this is a proportionate step to prevent a child from being taken away from the custodial parent and home jurisdiction. Next, we've considered members' comments and also relevant provisions in the matrimonial proceedings and property ordinance. And we will be consulting the judiciary on a suggestion to include a new provision to empower the CFR to vary, suspend or discharge orders made by it under the CACO. Coming to the views of the child and legal representation for children under the CACO. Now, in family and matrimonial proceedings, the views of the child can be brought to the court's attention in a number of ways, including by being included in the social welfare officer's report, by appointment of a separate representative, and by interviewing the child. In May as well as in July 2012, the guidance on the guidance on meeting children and the guidance on separate representation for children in matrimonial and family proceedings were issued respectively by the CJ, and they apply to children proceedings, including proceedings under the CACO. And the court may at its discretion meet with the child or appoint other or can consider appoint the official solicitor or guardian ad litem for the child. At present, under Article 13 of the Hague Convention, there is a defense, and that is the child objects to being returned and has attained an age and degree of maturity at which it is appropriate to take account of his views. And in this case, the court may order official solicitor to represent the child for parental child adoption cases under the Hague Convention. Similarly, should the court consider that meeting with the child or separate representation is in the best interest of the child in proceedings under the bill, it may so order as appropriate. And then application of habeas corpus under the High Court Ordinance, Section 20A, states that the person concerned may apply, or another person can apply on that person's behalf. Habeas corpus can generally be invoked in cases of persons being unlawfully detained, and thus we don't think it is necessary to set out the right of the child to pursue habeas corpus applications under Section 22A of the High Court Ordinance in the CACO. We understand that there have been precedents whereby the courts in Taiwan recognized and enforced matrimonial judgments made in Hong Kong regarding the assistance to be provided to the left-behind parent whose child has been adopted to the mainland and Taiwan. The police will assess the case and contact the relevant authorities to request them to locate and protect the child as appropriate. The police may also pass the contacts for the parents, follow up with the relevant authorities. As in cases of Hong Kong residents in distress outside Hong Kong, the left-behind parent may also contact the Immigration Department for assistance. The Immigration Department, the police, and the SWD are discussing the workflow and detailed arrangements to implement the bill. Administrative guidelines will be prepared. Thank you. So can I ask members whether they've got questions on this paper? Mr. Wong Yok Man. With regard to the criminalization of parental child abduction, the administration said it agreed with the LRC in that there was no evidence that there was a serious problem of children being adopted within to or from Hong Kong. And so the administration did not think that the act should be criminalized. No, but I don't think the act should not be criminalized because there is not a serious problem at the moment. You're saying that there is the power to detain a child when he or she is about to be removed out of Hong Kong in breach of a stop order. But I think this is not enough. Now, because if the child has been removed from Hong Kong, then all the remedies will no longer be effective. And so I just want the administration to reconsider the suggestion of criminalization. Yes, it's true that at the moment we don't have a serious problem of parental child abduction, but then such acts may occur. And so I do not agree with the administration on this one. I am of the view that the CFI should be empowered to vary, suspend, or discharge orders. And then on recognition and enforcement of Hong Kong matrimonial court orders in Taiwan and assistance to parents whose child has been adopted to the mainland and Taiwan, I hope that we can establish a mechanism or a system. For example, you may seek to sign agreements with these places so that a formal mechanism or system can be established. Yes, I want Ms. Chair to respond, especially to the issue of criminalization. Mr. Chair, now I think I've already outlined the administration's position, and we've also stated that position in the paper, but we're willing to reconsider the matter. What is meant by the remark that we don't have a very serious problem at the moment? We don't need to have 100 cases in order to support the argument of criminalization. In fact, one such case is really one too many. So please reconsider the matter. Yes, thank you. Ms. Sit Ho. I agree. You're saying that we don't have a serious problem, and I hope that you won't just look at the number of cases in coming to this conclusion. In fact, we've dealt with domestic violence cases, and they were applying for separation or divorce, and according to the mother, one party might take the child to the mainland or to other places, and the child never appeared again. So that would have very serious ramifications for the child and for the parent. So please do not just look at the number of cases in concluding that we don't have a serious problem at the moment. And for the two parties to marriage, and if the family proceedings have not started, then what if one spouse takes the child out of Hong Kong? Now, but maybe the spouse may say that in fact, he or she doesn't want to abduct the child. He or she is just taking the child to a trip. But then if there is a domestic violence case, and if the case goes to the police station, then I think the police should take down the names of the children, and the children should be put on the list, just like the list which the immigration department used yesterday at the airport to intercept the alleged employer. So in other words, if there's a domestic violence case, if then no one party should be allowed to take the child out of Hong Kong. So in other words, with before the completion of the proceedings, before the court gives consent, children must not be allowed to be removed out of Hong Kong. So perhaps you can put the names of such children on the list. Yes, we'll consider these suggestions. Thank you, Chairman. When will the judiciary give you a reply on the suggestion to empower the CFI to vary, suspend, or discharge orders? They haven't told us when they will come back to us, but we will be liaising with them. But then will that affect the progress of the work of the Bills Committee? Because we want to have the judiciary's reply, and in the light of their reply, you may have to amend the bill. We will inform the BC as soon as possible when the judiciary will give us a reply. And then concerning habeas corpus, you are of the view that the inherent jurisdiction of the courts in respect of granting habeas corpus will not be affected by this bill. But then, say, if an order is issued, then the person concerned can either apply or to appeal, or he or she can apply to the CFI for varying the order, or he or she can choose to apply for habeas corpus. Is it that? So I want to know the relationship among these three routes. Chairman, yes, Ms. Ho. As far as I understand, the bill will not affect the existing mechanism. So if there are three routes available at the moment, then there will still be three routes. So he or she can appeal, he or she can go to the CFI for a variation of the order, or he or she can apply for habeas corpus. Yes, correct. Legal advisor? Yes, Chairman. I understand that the administration doesn't want to set out the right to pursue habeas corpus in this bill again. So there will be administrative guidelines. Then, do the authorized officers need to let the child or the parents concerned or the guardians concerned know that they can seek legal representation, they can contact lawyers, and they can apply for habeas corpus in accordance with the High Court ordinance? Yes, the administrative guidelines are being prepared, and we will be looking at this issue. So those will be internal guidelines, right? Is it that you can let us have a look at those guidelines now? We're now in the preliminary stage of discussion. We are at the stage only discussing the workflow. We understand that members do have concerns. And of course, we will carefully consider members' concerns and suggestions. And we will also report back to members as to how we seek to address such concerns. Ms. Sit Ho. I think the administrative guidelines are important, Chairman. we may not want to criminalize all acts involving parents and children, but at the same time we have to offer adequate protection. So even if people may report the cases to the police, but then there are other social welfare organizations handling domestic violence cases, and many domestic violence cases occur in new arrival families. In fact, local Hong Kong people may know how to report to the police, but they may not know how to seek assistance through other channels. So I think what is important is that the names of such children be brought to the attention of the immigration department, and so that these children cannot be removed out of Hong Kong easily. And I think social workers should also be involved.
Well, we're talking about the personal data of the children. We have to be careful about that, but certainly we will consider your point. Mr. Chairman, I had a survey concerning policies dealing with domestic violence. It was found that even some social workers were not aware of the procedures involved so as to protect the victims in the cases that social workers handle. So if there are internal guidelines for the administration, then I would suggest that you talk to the professional bodies so that when they train social workers in relation to domestic violence, they are made aware of the procedures so that when something happens, they know which government department to turn to and that they have to report to the police. Thank you. All right. I think this point is clear. If no other members have got other follow-up questions, then I suggest that we can go into the cross-by-cross scrutiny. We are awaiting the reply from the judiciary. In the interim, I think we can look at the various clauses. Ms. Xie. Mr. Chairman, so you suggest that we should proceed with the cross-by-cross scrutiny? Yes. Well, I think members have got this copy. That is Child Abduction Legislation Miscellaneous Amendments Bill 2013, Clause 1, Part 1. Well, first of all, let me talk about the preamble. We have amended the preamble. This is a bill to amend the Child Abduction and Custody Ordinance and other enactments to provide for combating child abduction and for better implementing the Convention on the Civil Aspects of International Child Abduction and for related matters. So we want to clarify the scope of the bill. Please continue. Short title, commencement, I don't propose to go over them again. And then clause 4. We have defined what is meant by a place of safety. Includes a place listed in the schedule to the protection of children and juveniles, places of refuge order, Cap 213, subleg B. And then a number of orders may be issued by the courts, like the recovery court order, stop order, and prohibition order. Ms. Sit Ho, sorry, I want to go back to the commencement date. Understanding is that after we've enacted the amendments, we have to wait for the Secretary to appoint a date of commencement. What will he be waiting for? Internal guidelines? Yes, one of them being the internal guidelines. And then the Rules Committee has to amend certain rules so as to allow the courts to come up with the orders that would be required in such procedures. So you enact the bill, and then it means that you provide for the framework, and then the courts have to follow that up. I'm interested in the procedural side of the matter. So there will be a gazettal notice to appoint a date of commencement. Does it mean that it will come in the form of a piece of subsidiary legislation so that the LegCo will have the chance to go through it again. That is, what procedural changes will be made by the judiciary, and we'll have a look of the internal guidelines, right? Yes, there will be subsidiary legislation for the date of commencement. Fine, Mr. Chair. And then clause 6, we are going to substitute the existing section 7. That's about powers of the Court of First Instance in applications under this ordinance. The CFI may specify that the child or either or both of the parents should appear at the hearing of the application so as to enable the court to have a full picture before coming to a decision. 7.2 CFI. 7.2, it says this section does not affect the powers of the CFI that are exercisable apart from this section. Does it mean that wardship that we usually refer to will not be affected? Correct. Sorry, I've missed a point. Still on the commencement date. Usually it is in the form of negative vetting for subsidiary legislation covering commencement dates. And then we only get 7 weeks to look at it. But then I'm not sure whether there will be adequate time because concerned groups in relation to family violence may want to ask for a public hearing. So I would suggest that the administration do the following. Before you propose to the Secretary to have a Gazette notice, you present the draft to the relevant panel so that the panel can have a look, and then we can also take on board the views of the deputations before we move on to the 7 weeks time involved in negative vetting. There may be disputes, and then the 7 weeks may not be adequate. Thank you for your point. I'll consider it. No, don't just say you consider it. I think surely you have to present the guidelines to the Welfare Services Panel. Certainly, Mr. Chairman, I agree with you. For the DV concerned groups, all along, and in fact, their members can speak from personal experience, so they're really anxious about it. So I don't think we can rush through it in a framework of 4 weeks plus 3 weeks. We are aware of members' concerns. For the guidelines, they are supposed to contain a lot of details. I'm not probably we won't be presenting the entire volume, but then those areas of concern to you will be highlighted to you. Yes, you present it to the panel so that we don't have to spend too much time on the scrutiny of the commencement date subsidiary legislation. I think you have finished with Section 7, right? What follows? That is, clauses 7, 8, and 9 are rather technical. Then I want to go to Section 15. The definition of child being given further clarification. It includes a child of the family as defined by Section 2.1 of the Matrimonial Proceedings and Property Ordinance. It applies to a child who is under the age of 18. And then we talk about the removal order and the stop order. We set out the circumstances under which no one can be removed out of Hong Kong. Again, we say that unless the CFI has other orders, this can be made ex parte. Ms. Sit Ho, before we started the meeting, I asked the Secretariat this question. I want to know, for children under the age of 18, do they travel on their own travel documents? For the home return permits for very young children, they haven't got their own documents. They have to travel together with their parents. What about Immigration Department? They may. A child, irrespective of the age, may have his own travel documents. Well, for the immigration, so it will stop somebody from going out of Hong Kong if he appears to be 14 or 15 years of age. Well, if the court has already handed down a prohibition order, then either of the parent may exercise discretion to inform the immigration department, which will then put the name of the child on a list. So when the child is to go through the immigration counter, then the immigration officer will check whether the name appears on the list. And then the immigration department staff would also do the following. When there is reasonable suspicion that a child is being removed from Hong Kong against a court order, then the officer can detain the child and prevent him from leaving Hong Kong. Mr. Chairman, what I mean is that somebody is 16 years of age, he can travel on his own using his own travel document. What can we do? He doesn't have to be taken out of Hong Kong. I think we already have such cases. They don't have to travel together with their parents. They're not being taken out of Hong Kong. They're not being removed out of Hong Kong. Let's try. If there isn't reasonable suspicion that somebody is being abducted or removed from Hong Kong, then we will give the green light. Unless there's reasonable suspicion, then we will stop the child. And then we will carry out some inquiries. We'll find out why this person is leaving Hong Kong on his own. According to our present procedures, if it is found that he may be the victim of a case of abduction, then he will not be allowed to go through immigration. So he will be prevented from leaving Hong Kong. Correct. I think I still have some questions in mind, but I will ask the questions later on. It doesn't matter. Let's come back to section 15. I've just covered that. Do you have other questions? If not, just pause there, please. Yes, you don't need to go so fast. Our legal advisor, anything? Ms. Xie, please continue. Section 16. Again, it is about the new order to be issued by the court, and there is the location order. Under the Hague Convention, we have some proceedings. Now, the court will be empowered to request a person, any person under 2A, to provide the court with applicable information that the person has or may reasonably obtain about the child. And under 2B, a public officer is required to provide the court with applicable information that the officer has or may reasonably obtain in an official capacity about the child. As to who may apply for a location order from the court, well, it could be any party to the applicable proceedings or the Secretary for Justice. For such an order, again, it can be applied ex parte. If I may also mention one point, please turn to subsection 6. The person to whom the location order applies must comply with it, regardless of whether or not there is any restriction imposed by a law or agreement, or the application information is subject to legal professional privilege. Under subsection 7, a person is not excused from complying with a location order only because doing so may incriminate the person or the person's spouse. Subparagraph or subsection 8, however, a statement made by a person in compliance with a location order is not admissible in evidence against the person or against the person's spouse in proceedings for an offense other than perjury. Mr. Chairman, yes, Sito. Well, let me check whether my understanding is correct. It means that if a family hasn't entered the judicial proceedings, that is, if the court hasn't invoked any proceedings concerning the custody, then in fact either of the parents may take away the child and we can do nothing about it. Correct.
So,
And so, when the case starts and then up till the courts start dealing with the case, in the interim there's no protection. Can I respond? Can I respond? Yes, please. We do understand the members' concern. Now, under the existing ordinance, even if the courts haven't issued an order, so long as one party has made an application, then the immigration department can stop the child at the border. You mean when the writ has been filed? Chairman. To the child, it means the procedures are there pending a decision by the court. And so the child can be stopped at the border. Now, starting from the moment a report is made to the police and until the matter goes to court, we have a sort of vacuum in between, and we have to make sure that this vacuum is the duration of this vacuum is kept to a minimum. But then, once an application is made to the CFI under this ordinance, then the vacuum will come to an end. In other words, the immigration department will have to be notified. Now, once there is an application for divorce or for custody, then that means the case is they're pending the decision of the court. And then a parent has to notify the immigration department in order to have the name of the child put on the list. Now, but then for some families in the grassroots sector, maybe the spouse may need to apply for legal aid first before starting divorce proceedings. Is that right? Can we provide a reply after the meeting? But if the I'm just worried that if that vacuum or the duration of the vacuum is too long, then it may be possible to bring the child out of Hong Kong to the North Pole. What exactly do you mean? Now, say a report is made to the police. All right. You mean if there is a domestic violence case and then a report is made to the police? Yes, and then the spouse may consider divorce and then may decide to apply for divorce, and then she may need to apply for legal aid. Because I'm not familiar with these procedures, is it that once legal aid has been approved, then the case will be in the hands of the family court? I want to have a flow chart. I just want to know whether the duration of the vacuum will be longer for spouses who need legal aid. Now, the parent can make an application to the CFI or the High Court, and then so that there will be a summons. And the summons will be brought to the immigration department, and the immigration department will, at the border crossing points, stop the child. And I think these procedures are separate from the procedures to apply for legal aid and divorce. Is it that the two these procedures can proceed in parallel? Now, I think we can respond only after the meeting, but the parent may need to apply for legal aid, but at the same time, the parent should apply to the court. Not just applying for divorce, but also to apply for a prohibition order. So we want to have a flow chart from the administration, so that we know what the victims of domestic violence should pay attention to at different stages, and which department will be taking what action at what stage. Yes, I think that's a good suggestion from Ms. Sit-Ho. We understand that the CFI has jurisdiction, but many such cases are dealt with in the family courts at the district court level. And so if the judge has been dealing with the case, and the judge is familiar with the circumstances of the child and the parents, then you have to require the parent to make another application at the High Court. But then the hearing judge may not be familiar with the case, so that would mean duplication of judicial resources. I understand that if the family court is dealing with a particular case, then I think the judge may also want to deal with the case in relation to the child. But then here talking about the CFI, because we need to implement the Vague Convention, and such cases are heard by the CFI. But can you also allow the family courts at the district court level to deal with such cases? Then we'll have to study the whole matter again. 95% of the divorce cases in Hong Kong are dealt with by family courts at the district court level. But under this bill, these judges cannot make orders. Only the High Court can. I understand that the jurisdiction of this High Court comes from the Hague Convention. Then is it that only High Court judges can deal with such applications? Can I invite DOJ colleagues familiar with the Hague Convention to answer this question? Yes, under the Hague Convention procedures, the cases have to go to the High Court, but I do understand the members' concern. But then I think we will have to consider such procedures. My understanding is that for applications under the Hague Convention, they are dealt with by the CFI, and so in this bill, you are proposing that the cases go to the CFI. But then, for many of these cases, in fact, there are also family cases going on. But I think these proceedings and family proceedings are separate proceedings. Now, when we look at international conventions, UN sanctions, we always say that we are looking at the spirit. It's not like in the Merchant of Venice, 1 pound of flesh, no blood, no hair. So at the moment, there is a division of labor among the various levels of court. So, now at the moment, family proceedings are dealt with by the district courts, and now we have these cases which will be dealt with by the High Court. I don't think the social workers will know this very fine division of labor. I'm just worried that those who are supposed to be able to help these clients may not know that the clients or the parents must make an application to the High Court as soon as possible. So I understand that you've given the jurisdiction to the CFI. But in theory, there is nothing preventing the granting of similar jurisdiction or the same jurisdiction to the district courts, to the family courts. Judicial resources are very limited. And so if we have, and I believe the judiciary will welcome the idea of allowing family courts to look at such cases. Sometimes when we go to court, the judge may ask why the case is dealt with as a separate case and not as a related case to be dealt with by another court. But of course, the Hague Convention says the CFI. But then while we are still considering this bill, can you ask the judiciary whether they would welcome the idea of extending the jurisdiction to family courts at the district court level? Because it would be good if these cases can be dealt with by judges of the family courts. Yes, Chairman, will follow up. But I want to point out that, in fact, we had consulted the judiciary before we prepared the bill. And what was their response? They expressed consent. So, Ms. Chair, please bring our suggestion back to the judiciary. Now, if the judiciary thinks that it's okay to have these cases dealt with by the CFI, then we will no longer need to be concerned about possible duplication of judicial resources. Ms. Ho. Now, we have the same concern, though the reasons may be different. In my view, in order if we can avoid duplication, then we can have the cases dealt with as quickly as possible. So, and I think the administration should bring the matter up with the judiciary again. Thank you. Legal advisor. Yes, may I refer to 16(6)(b). The applicable information is subject to legal professional privilege. Now, if this bill is passed, then does it mean that the lawyers of the two parents may need to disclose the information that would otherwise be subject to legal professional privilege? And I want to know whether the legal bodies have been consulted. We haven't received any views on this. 6B. If the information is subject to legal profession privilege, and there is no need to disclose the information, is that right? Now say if the parent knows where the child is, then the information has to be made available. I want to know whether the Law Society or the legal bodies have expressed any views. They haven't expressed any views on this matter.
Okay.
其實
係法律顧問。
係咁，多謝。
Our legal advisor, thank you. Mr. Chairman, well, LPP is constitutionally protected. I want to know about the necessity of this particular provision. Well, I think we try to discover the location of the child as much as possible, as early as possible. So this is for the interest of the child, but we are open to your comments. I can understand the worry of our legal advisor. Well, it is a right protected by our constitution, namely the basic law. So you must justify the proportionality. Now you are going to exempt the LPP. I'm afraid you will open yourself to challenges. I just wondered if you can improve the drafting so as to specify the circumstances and the information to be exempted from LPP so that the court can request the production. So perhaps you can make it to say that only the court and the law enforcement agencies will be given the information, and the information thus produced can only be used for the sake of this order. And information, I mean anybody in possession of such information, in possession of such documents, cannot use it for other purposes and cannot make it public. In the interpretation section, we have defined the information in relation to child means information about the child's whereabouts or other circumstances relevant to locating the child. But then it can cover quite a lot. Thank you, Chair, for your comment. We'll go back to reconsider the drafting. Sid Ho. For this point, what about the overseas experience? When they try to prevent international child abduction, I want to know whether they've got something similar. If so, please give us the examples. We don't want Hong Kong to be the exceptional case. We don't want to be the first one to take away the protection of LPP, while at the same time it is in breach of the basic law. I think you need to give it more details. I think you have to specify that it covers a very narrow scope and only to be invoked under very exceptional circumstances. Thank you. We have made reference to overseas experience and overseas provisions concerning international child abduction. We have also made reference to the LRC's report, but in the light of members' concern, we'll go back to reconsider it in great details. Well, for such cases, probably we are talking about a couple. They are in the middle of a divorce proceeding. So if either party is to apply for such an order, and if he or she can get the communication between the spouse and the lawyer, and one day in a court proceeding, if the spouse is to use it for other purposes, this will go against the LPP, and in fact, the other party will be jeopardized or prejudiced, because if a party can get hold of the communication between the other party and the lawyer, one day the information can be used for other purposes, and then the impact can be huge. Well, applicable information is being defined here as to the uses that the information will be put. We can reconsider it. Yes, just a moment, please. Our legal advisor. For Section 16, if I may comment on the Chinese drafting. 16(2)(b). In relation to requiring a public officer to provide the court with applicable information that the officer has or may reasonably obtain, blah blah blah. So in Chinese, it's 按你可取得的 may reasonably obtain. So in English, it says obtain reasonably. The Chinese rendition is not too far away from it, but in English, I think it is a little bit different. For the Chinese version, 按你 what sort of 理? Would it be 法理 or whatever? So perhaps you should try to align the two. I would suggest that you use 可合理取得 for reasonably obtain. Probably such a rendition would be better, more equivalent. We have reasonable, and we call it 合理範圍. Otherwise, if you use 按理 in Chinese, it can be interpreted differently. Yes, I agree. 按理 cannot really be said to be equivalent to reasonably obtain. You better change it. Say, for example, 合理取得. For Section 16, any other questions? Not for the time being. Yes, sit hold. 16(7). How many persons are we talking about? We have a person, the person's spouse, the person. So are we talking about 3 different persons or what? 16(7). Page 6 of the marked up copy. We are talking about 2 persons. First of all, the court require a person to provide some information. So that person and the person's spouse. Are we talking about the parents of the child? Or would we be involving a non-parent? Would it be a case that the child is being removed by a next of kin or a close relative? It can cover persons other than parents. Well, I think the person involved and the spouse, if they have any information which upon disclosure may get them into criminal consequences, they will still not be spared from the responsibility to disclose. So it will include but not limited to the parents of the child. Yes, it can be anybody. Okay. Section 17. Again, this is about a new order, namely recovery order. Like Section 16, the applicable proceedings means proceedings under the Hague Convention. If a recovery order has been made, then the court may require a person to return or deliver the child to another person specified by the court. This also authorizes or directs a police officer to use force in the course of finding the child, and in the course of it, The police officer may stop and search a vehicle, vessel, or aircraft and enter and search a place. 2C. The court may authorize or direct a police officer to recover the child. And D. To return or deliver the recovered child to the specified person. Subsection E. If the child cannot be returned to the specified person, then the officer may find the child, keep the child in a place of safety until the return or delivery of the child to the specified person. If within reasonable time the specified person cannot be contacted, then the court may authorize or direct the Director of Social Welfare to take actions that the Director considers appropriate. The court may also give directions about the day-to-day care of the child until the return of the child to the specified person, as to whom may apply for a recovery order. He or she can be a party to the applicable proceedings, that is, proceedings under the Hague Convention. The Secretary for Justice may also apply, and it may be made ex parte. For this order, I want to know whether this will empower the police the following. Usually, for orders like this, the police may search a premises and collect evidence, so a seizure power will be given to the police officers. But then this is absent from this provision. Is it because the main purpose of the section is to find the child and return the child to a specified person, a person recognized by the court, so the police powers will be confined to such a degree? In other words, while enforcing the order, he cannot do things other than what is allowed under the law in this section. Sit-hold. Authorization. Who will be authorized? Are you interested in 2B? Yes, 17(2) talks a lot about authorization and directing police officers. We can appreciate who police officers will be authorized. Who else will authorize? Well, police officers will be authorized or directed. So the object of authorization and direction will both be police officers. For 2F, Mr. Chairman, if the specified person cannot be contacted within reasonable time, authorizing or directing the DSW to take the follow-up actions that the director considers appropriate. Well, in the Chinese version and in the English version as well, when we talk about authorizing, so I suppose that the subject is always the court of first instance, right? Yes, if I understand it correctly. But then it is a bit confusing. Now, for B, C, D, and E is clear, because in Chinese you'll find the subject being the CFI, and then the CFI authorizes so and so forth. Here, you start the sentence with, if the specified person cannot be contacted, and then authorizing, blah, blah, blah. Then you have the misunderstanding in the Chinese version that the police authorizes.
Contacted within a reasonable time. Hyphen 係咪應該就唔係淨係寫 authorizing or directing 就
I think you should draft it differently.
authorize or direct the director
我意思淨係咁啦，就係你喺中文嗰度、英文嗰度加多個原訟法庭落去。
Yes, this is exactly what I want to point out. Perhaps we should also repeat the court of first instance again. That is, the authorization comes from the CFI. The power rests with the CFI rather than the police. The way it is being drafted now seems to imply that the police will authorize or inform or tell the DSW to do certain things.
No, para 2 says that the CFI can or may do certain things. So A to G are the powers of the CFI, but we'll look at this again. This language is not clear enough. Yes, I understand that these are the powers of the CFI, but I think the language should be clearer.
你講緊 G 嗰度呢，
G, giving directions about the day-to-day care of the child. What directions do you have in mind? Including the child's schooling. Then the scope can be very broad. So directions can be issued about the day-to-day care of the child. Are there any questions? So G. Now you have to try to find the child and return the child. And concerning these directions, to whom are these directions issued or given? Now, is it that the child is with a certain public organization and has not been returned to the specified person? Yes. All right. So the police will try to find the child. And G, now where will the child be under G? Now let's look at E and F. Now if the child can't be returned to a specified person, the specified person within a reasonable time, then the child will be with the SWD. The SWD will take the child to a place to wait till the child can be returned to the specified person. Okay. Day-to-day care. So SWD. So the work is done by the SWD. Yes. Next one. Uh, 18. CFI may make order prohibiting removal of child from Hong Kong except to habitual residents. So first of all, the definition of home state. And that means in relation to a child, meaning the contracting state of the child's habitual residence. This section applies to a child if a judicial or administrative authority of the child's home state has made an order providing for the child to be taken to Hong Kong temporarily, or whether or not also to another jurisdiction for enabling a person to exercise the rights of access to the child. And or if these conditions are met, a judicial or administrative authority of a contracting state has made a decision or a determination that the child has been wrongfully removed to or retained in that state within the meaning of Article 3 of the Convention. Two, that authority has made an order providing for the return of the child to the child's home state via Hong Kong, whether or not also via another jurisdiction. And the child is in or will be entering Hong Kong in transit on return to the child's home state. Also, the application has to be made by the S4J. And then the CFI may, on application by the S4J, make an order prohibiting the removal of the child from Hong Kong to a jurisdiction other than the child's home state or another jurisdiction, as may be specified in the order mentioned in subsection 2A or B2. And the Secretary for Justice may make an application under the section on request by the central authority of a contracting state, and the application may be made ex parte. So all the three conditions under B have to be met. 1. A judicial or administrative authority of a contracting state has made a decision or other determination that a child has been wrongfully removed to or retained in that state within the meaning of Article 3 of the Convention. I think the English version is clear, but the Chinese version is not. Has made a decision or other determination that the child has been wrongfully removed to or retained. So why is it that in the Chinese version you have 該國 2 times and 該兒童 2 times? No need to repeat 該兒童 in the Chinese version, and no need to repeat 該國, because so it's really so repetitive. So the department drafts the legislation in English, and then gives a literal translation in Chinese. Now the English version is so much clearer. You do not need to repeat the child twice. Just use the word or, and it will be okay. But the Chinese is so repetitive. 該兒童 and 該國 are repeated. Thank you. Yes, we'll follow up. I'm not being fastidious, but I think the laws should be clear. So in fact, when I was filibustering in the council, I made a lot of comments on the Chinese versions of our legislation. Now, I understand that the legislation is drafted in English, but the Chinese text enjoys the same legal effect and status. Yes. So please try to improve upon the Chinese version. Or say if there is a third party who has a legitimate interest concerning whether the child should be returned to the home state, will that third party or third person be allowed to intervene in the proceedings under Section 18? Yes, perhaps I can invite the D of J to supplement on this one. Chairman, say an Australian child is brought to the U.S. and the U.S. courts have ruled that that would amount to abduction under the Hague Convention. And so the U.S. court may issue a recovery order. And then the central authority in the U.S. may contact the central authority in Hong Kong, because when the child is brought back to Australia from the U.S., then the child may go via Hong Kong, and as a result, we'll need to apply for an order to the court, for an order from the court, so that the child can, during the short stay in Hong Kong, smoothly go back to Australia. And then considering whether there are third parties who have interest in the matter. Now, the father or the mother may be waiting in Australia for the child, but then the U.S. Central Authority has already made an application to the Central Authority in Hong Kong, and so the Central Authority in Hong Kong can take appropriate action, and so there would not be any need for the third party. So in other words, the Hong Kong courts do not have any discretion in implementing the order. Hong Kong courts do have the discretion. In other words, the Hong Kong courts do not have to enforce the order from another country. Yes, of course. But what if there are concerned parties who want to make representations to the courts? Now, are you talking about the recovery order? Now, you gave a simple example from the U.S. via Hong Kong to Australia. What if the child is to be returned to a country and there is reasonable suspicion that the child will be subject to certain treatment if he is sent back to that country, and such treatment is unacceptable to us in Hong Kong? And so can some interested parties apply to the courts to intervene in the proceedings under Section 18? Now, if a U.S. court hands down the return order, and if there is a suspicion that the child will be subject to certain treatment in Australia that will be unacceptable, then when the central authority in the U.S. will liaise with the central authority in Australia, to make sure that the child, if returned to Australia, will be taken good care of. But then the Hong Kong courts do have the discretion. The Hong Kong courts can decide whether to enforce the order. Say if someone can produce new evidence to show that the child may be subject to certain treatment upon being returned to Australia. And if these interested parties want to make submissions to the Hong Kong courts against the return of the child to Australia, then what legal standing can the interested parties intervene? Section 18 empowers the CFI to assist other courts in other countries. Hong Kong courts cannot overturn orders handed down by foreign courts. So CFI may not want to grant a mirror order, but it doesn't mean that the order from the foreign court is void. So our local courts will not or doesn't have or do not have any standing as to whether the child should be returned from the U.S. to Australia. So in other words, our courts only have discretion with regard to the following. That is, the child will be in Hong Kong and will not be sent to another country. The child will only be returned to Australia. Now, because for the U.S. Court order, the proceedings have been completed, and that was why I was asking about the discretion enjoyed by Hong Kong courts. So, the discretion of the Hong Kong courts applies only to the stay of the child in Hong Kong, not whether the child should be sent back to Australia from the U.S. And our courts can decide whether to issue a mirror order. So whether in other words, whether the child should be sent back to Australia. But what if a third party wants to make a submission to court concerning the mirror order? What sort of submission? Now, say, I think the child should not be sent back or returned to Australia because he or she will be subject to certain treatment if he or she is returned to Australia. But then if such arguments need to be put forward, they should have been put forward in the U.S. when the Hague proceedings were in progress.
Mr. Chairman, can I ask a question concerning one country, two systems? In 18.3, it says that there can be an order prohibiting the removal of the child from Hong Kong to a jurisdiction other than A, the child's home state. Now, the mainland and Hong Kong have two different judiciaries. But then Hong Kong and the mainland will be counted as one state. So how are we going to align it with one country, two systems? Mr. Chair. For Section 18, it applies to Hague Convention proceedings. The mainland isn't a signatory. I don't know whether I'm asking a foolish question, but then the title of Section 18 says, an order prohibiting removal of child from Hong Kong except to habitual residents. Well, in the mainland, they practice in a different judiciary, but no one can say that the mainland is not part of our home state. Well, the way you have drafted it, it means that we cannot protect the child. In other words, you can't prevent him from being taken to the home state. In other words, a parent may take a child to the mainland. I can understand your question. You found the same problem under 2A and B3 and also 3A. Because the term home state is being used here. In Hong Kong, I think you suppose it to mean Hong Kong and not including the mainland. No one would try to mix it up. I think it's a matter of the party to the convention. Home state here means the contracting state of the child's habitual residence. So a definition has been given. I don't think there should be this sort of suspicion. But of course, politically, you would say that going to the mainland would be going back to one's home state. But what about the court? I think we're talking about the jurisdiction. Our courts are part of our own jurisdiction, not the mainland, not Taiwan. So I think it will be confined to this jurisdiction. I think the provision is very clear here. There is under 18(1), home state in relation to a child means the contracting state of the child's habitual residence. So the contracting state is the same as the jurisdiction. China is not a contracting state. So with all such, it won't give rise to confusion. Had you changed it to Hong Kong, it would give rise to another sort of confusion. Sit Ho. I'm not trying to pick on the issue of one country, two systems for its own sake. However, one day when we have a case, then both parties will ask the lawyers to find something in the law that will suit their purpose. So I think it's better for you to consider it and try to have clearer drafting. I don't know whether it's good or not. We've only got one country, two systems in Hong Kong and Macau, and nowhere else. In this case, I would prefer the usage of jurisdiction rather than home state. For subsection 1 and 2, they are not presenting any problem, because in subsection 3 you have the home state or another jurisdiction. Yes, please go back to consider it. Section 19. When the court has made a stop order, that is, if the child is at the boundary, then the Director of Immigration would say that he cannot go through the immigration. (19)(1) says that Director means the Director of Immigration, and then this section would apply if a stop order has been made in relation to a child by the court, or an application for a prohibition order is still pending. In this case, the parent may choose to inform the Director of Immigration. For section 20, or rather 19(3), it talks about the detention. There is some cross-referencing in 20. That is, an applicant for a prohibition order may notify the director that the order has been made or that the application is pending. And then an applicant for a recovery order may notify the director that the order has been made. An applicant for a stop order that has been revived after suspension may also notify the director. For 19(4), if an applicant has given a notification to the Director of Immigration, then the applicant must, as far as practicable, inform the following persons. You find them in A and B. Certain persons will be specified under subsection A. If a court order concerning the rights of custody or for access to the child is enforced, the person or each of such persons who has and is exercising those rights under the order, or B, if proceedings concerning those rights are pending in a court, then each party to the proceedings has to be notified by the applicant when the applicant has notified the Director of Immigration. Subsection 5. If an applicant has already given notification, then as far as practicable, the notification should be related to the parties to the related applicable proceedings. In other words, all relevant persons have to be notified. Subsection 6, even if the applicant has not notified the relevant persons in relation to the fact that a stop order has been made and the immigration has been notified, the validity will not be affected, and the detention in Section 20 will not be affected. Subsection 8, for the purposes of Section 20, an applicant for a stop order who has given a notification under subsection 3 must, or a person affected by the order or the application may, notify the director about the matter mentioned. Notification of the director should be carried out in the way mentioned in 9A and B, given in a manner and form specified by the director and accompanied by the supporting documents. Mr. Wong. Subsection 9. It mentions subsection 3 or subsection 8. The notification must be given in a manner or form specified by the director. The Chinese, well, 給予 is supposed to be a rendition for given in. I think for the Chinese version, you don't need the phrase 給予. Because in Chinese, it says 第3或8款所指嘅通知須以處長指明的方式和格式及附有處長要求嘅支持文件。So you should preference to say 給予 for given. Yes, please reconsider it. For 19(3)(a), if it is pending, then you can inform the director immediately. Now, if you are putting an application, you may notify the Director of Immigration directly, and then the immigration will stop the child from leaving. Now, there are two questions here. First of all, if the application has been lodged, but then it will take a long time to wait for a chance to be heard, what will the director do? Well, somebody may deliberately put in an application, but will refrain from getting it listed. Now, in Chinese, it is 待決 for pending. I think in this case, the Chinese is clearer. Pending. Does it include that we are getting ready for an application? But in fact, what is meant here is that you must have lodged the application and is waiting for its turn to be heard. Yes, in this case, the English version has to be made clearer. In Chinese, 待決 is clearer, is waiting to be adjudicated or decided by the court. In English, pending covers much more than waiting for a decision. Yes, Mr. Chairman, we will consider it. What about if an application has been lodged and you may have to wait for 6 months' time? Does it mean that the child cannot be removed for 6 months? What about if somebody is to abuse the procedures? He lodges an application, but he doesn't arrange for it to be heard. It is ex parte, and then someone will try to say that it should be inter parte, and then he may want to get about a year's time before it is heard, and then the child cannot leave Hong Kong pending a court decision. Sometimes people would try to abuse this procedure to prevent a child from leaving Hong Kong. Yes, we'll come back to this point later on. But then the other party may also put in an application at the same time. What? To stop the application? No, to make an order in another direction. We'll study it and come back to you. Well, we have to work for the best interest of the child. You can't detain the child for 1 year. It is impossible.
My worry is that some may make use of this provision and so as not to allow the child to leave Hong Kong. But then I'm worried that they will still not complete the procedures. But anyway, I think it's about time. So you can give us replies next time. All right, the meeting is adjourned and we'll fix the date for another meeting.